Morning, people. Right, so I got no response. This is with regards to Waitakere District Court and being harassed for filming on the footpath. I got no response from Philippa Chapman after my second email, which I sent her on the 28th of September in regards to her CSOs actions. And I've done a little bit more research since then, which I'll be filling you all in on. You'll find it quite interesting. But first off, after hearing nothing again from Philippa, on the 2nd of October, Chris Hurd, Senior Legal Counsel for Ministry of Justice, gave me an email out of the blue. Now, I didn't solicit his advice, I didn't ask for it. Philippa asked him to respond to me. And this is the letter that I received from Chris Hurd on the 2nd of October, and it reads as follows. Dear Mr. Keane, I have been forwarded your emails of the 24th and 28th of September 2018 to Philippa Chapman, Service Manager, regarding filming outside the Waitakere District Court. I have also watched the footage you posted on YouTube. Thanks for the watch. Enjoy the view count. The emails and the footage relate to 2 instances of you filming the front entrance of the court and being told that you cannot do so by court security. One preliminary point. Ms. Chapman is not responsible for court security, which is why she has not responded to your emails. I would appreciate it if you could edit her name out of your YouTube clip. Chris, I would appreciate it if when I call the 0800 courts number and ask for the information and explain what I need to talk to, that Holly or another call centre voice decide to actually give me the correct information. Philippa Chapman wouldn't have got my emails if the Ministry of Justice had put me through to the correct place. I asked for whoever's in charge of the court security. Holly gave me Philippa's contact details. And as for editing her name out of the clip, she's a public servant. No. Any information I get about you public servants will be going up on YouTube, so other people don't have the same grief I have when I simply want to correspond and talk and ask questions. This bit I like. You are correct. No. Really? You are correct that you are entitled to film the entrance of the court from the footpath. I didn't have any doubt in what I was doing. The ministry apologises that you were told that you could not, and we have taken steps to ensure that court security understand the correct position.
Assume the position.
Thank you, sir. May I have another? Thank you, sir. May I have another?
I understand that when you returned to film for a 3rd time, you did so without incident. Well, if you consider every time they saw me, them closing the entrance doors to try and hide what they're up to and be as opaque as possible, then that's without incident. They might want to teach them how to close the door properly, because he was getting frustrated with that door not closing. I note that in one of your clips, you questioned whether media were treated the same way when they filmed the entrance to the court. When media want to film the entrance to the court, they inform the court manager beforehand. Glad they have the contact details, so that arrangements can be made for the entry and exit of people who do not want to be filmed. You make arrangements for people with unreasonable expectations of privacy in a public building so they can exit and dodge a camera? Really? Secondly, the media don't need to ask your permission, and they don't need to inform you beforehand if they're standing on a public frickin' footpath filming the outside of the courtroom. They may need to contact the judge or JP if they want to film inside a courtroom itself, or the building services manager if they want to record inside the court building, because your policy, which isn't backed by law, says you got to. To film inside the court building, media need permission of the court manager. Like I just said, to film inside a courtroom, media need permission of the presiding judge. Like I just said, to film on a public footpath, they don't need permission from anyone. Neither do I. I also note the derogatory reference to one of the female court security officers in one of your clips, and he's given me a link to 1222 in part 2 of the 21st of September, which is when I called her, I forget the exact phrase, something little bitch. And if she hadn't have come out and acted like that, she wouldn't have been called that. If she'd come out and shown me respect and behaved herself, instead of coming out yapping like a little chihuahua, then she would have got the same reciprocated. I give what I get. That is unacceptable. Is it, Chris? Are you the behaviour police now? I forgot you're my father and can tell me what's acceptable and what's not. Last time I checked, I had the freedom of speech and I'll use it, mate. So you do not get to dictate to me what's acceptable and what is unacceptable. What's unacceptable is court security officer that are getting paid by everybody's tax money coming out into a public sidewalk where they have no jurisdiction, not identifying themselves, which is completely against the Court Security Act 1999. I forget the section, which states they must wear identity cards and identify themselves. Perhaps if I knew what their identity was, I wouldn't refer to them as Rottweilers, Oompa Loompas and Chihuahuas. Perhaps I'd actually know their frickin' name if they followed their rules and procedures correctly. Might want to get that sorted out too, Chris. If you wish to be treated with respect by court security, we suggest you do the same. We request that you edit that comment out of your clip. You can request all day long, Chris. I ain't editing jack shit. If you have a problem or think there's some breach in YouTube's policy, by all means, make a complaint to YouTube. You have the same ability as I do. Alright? If you want to be a sensitive creature and not like things like that, I suggest they treat members of the public with respect and follow their guidelines and policies, and if they treat me with respect, they'd get it back. It's that simple. Any public servant I speak to that treats me with respect, I reciprocate. Any public servant that oversteps their boundaries of authority, tries to bark at a member of the public for doing nothing illegal or unlawful, will not have my respect. Your request is denied, Chris. While I am writing to you, I will also address the matter of filming in the court buildings. Why? It's got absolutely nothing to do with the fact that your court security officers came out and harassed a member of the public on a footpath. So why address matters of filming in court buildings? You will recall our correspondence about that a few months ago. In one of your clips, you seem to imply that I agreed with you that you could film in a court building as long as you act lawfully. There's nothing implied, Chris. You expressed that. The only requirement in a public building is that the members of the public act lawfully. There's no implication. Once expressed, there is nothing left implied. I mean, you're a chief legal counsel. Surely you should understand that simple basic maxim. And I might seem angry. I'm not. I'm just trying to get my point through here. They are the public servants. You don't get to dictate to me what jersey I wear, what I can say on YouTube, or what I can post on YouTube. They have guidelines which I haven't breached. Nothing I have posted is not publicly accessible information. It's because the Ministry of Justice likes to keep everything hidden and opaque and as less transparent as possible that all this shit happens in the first place. Perhaps if the justice system was a more transparent and open society as it poses to be, it wouldn't be upset about cameras. I had planned to provide you with more detail about the legal basis on which the ministry can prohibit people filming in the court buildings. Had you? Shame you didn't, because until you can provide some evidence to back your point that you are making, your claim, onus probandi lies at your feet. Burden of proof is for you to prove, Chris, and perhaps if you had provided that information, I'd be more willing to listen. But as you haven't, you can say whatever you like. Absent fact, it's just a belief. However, as it is common law, i.e. case law, now don't get those confused, common law is not case law. Common law is an all-encompassing term. Case law refers to law that have been set in cases. It would take several hours of research to locate the relevant cases, and I simply have not had the time to do it. Well, perhaps you should do it before you try telling me what the ministry believes it can and can't do without facts to back it. In any event, amendments to the Court Security Act in Part 1 of the Court Matters Bill, which has its second reading in July, which is not coming into force or effect until the 1st of July 2020, so it's a couple of years away, but we'll be doing another video in regards to the Court Matters Bill that you've brought to my attention. Thank you so much, Chris. Will soon make the law on this matter much clearer. Really? 2 years from now, when it gets passed, if it gets passed, it might, if it's not amended beforehand. Clause 11 of the bill inserts a new Section 11A into the Act. For present purposes, the most relevant... For present purposes, it's irrelevant, because it's not presently law. Got it? The most relevant provisions are subsection 1 and 1A. 11A, right of the public to enter and remain in areas of court open to public. Now you've got to look at what do they define areas of court, and this is where what Chris doesn't insert into his pretty little email here to me, but I suggest you go and look at Section 3 of the Court Matters Bill, or Section 6 of the Court Matters Bill, where it redefines Section 3, or the interpretation of what court is. They're trying to say that the footpath, not just the boundary line from their forecourt, but the actual footpath, grass berges, and everywhere up to the roadside, and including the footpath adjacent to the court on the other side of the road, is considered part of the court. Alright, this is what this bill's trying to say. So, until it's law, Chris, it is not presently relevant. Alright. Section 1 of 11A states, a person may enter and remain in an area of the court that is open to the public if the person complies with given in requirements imposed by presiding judicial officers in a courtroom where proceedings are being heard that apply to that person. Well, not in a courtroom where proceedings are being heard, so that's irrelevant. In subsection B, all directions given and requirements imposed elsewhere in the court or by on behalf of the chief executive or by a court security officer that affect that person. Affect what person? A member of the public standing there? Or a person that's currently being heard? Which person? 11A subsection 1A, directions given or requirements imposed may, can also mean may not, without limitation, really, include directions or requirements allowing, with or without conditions, limiting or prohibiting the use of cell phones, cameras or recording equipment in a courtroom or elsewhere in the court. Elsewhere in the court means including the footpath if that bill gets passed by 2020. New section 11A1A requires anyone in the courtroom to comply with any directions and requirements of the presiding judge. Okay, path filming outside in public. The eyes cannot trespass. Similarly, section 11A1B requires anyone in the court building to comply with any their ID cards out after they've completed their training, like they're supposed to, and then they might have some authority in the matter. Section 11A1A provides that such directions or requirements can relate to allowing, with or without conditions, limiting or prohibiting the use of cell phones, cameras or recording equipment. Well, I hope they uphold that law right across the board. I hope they don't just pick on people that might come in and want to record something. I hope they prohibit the use of cell phones by the lawyers as well. I hope everybody walking around inside that court building, which is deemed part of the court, aren't using cell phones. In fact, why don't you just fucking take everybody's cell phone off them before they walk in there? Because that's what you're basically saying. Prohibit the use of cell phones or camera or recording equipment. So they're trying to say that nobody has the right to even use their cell phone in a court building. I know I've seen many a time. In fact, I've seen New Zealand police prosecutions old Mike McMurtry used his cell phone while standing inside a courtroom. So, is there a different rule for them and a different rule for the general public? Or perhaps they're immune. You guys like to hide behind your immunity. Moving on. Directions and requirements of the Chief Executive will usually be conveyed by signage, such as the existing signs prohibiting recording. I don't see any signs prohibiting recording. I see a cell phone with a Ghostbuster sign through it, which I take it means no cell phones in the courtroom. It doesn't say anything about no recording. I don't see that anywhere. In fact, I see signs all over the court buildings where they say recording is an operation. So, again, different rule for you guys versus us. Trying to be transparent, are we? Because it doesn't seem like it. What have you got to hide? What are you guys up to? Don't give me bullshit about private information, because last I checked, the whole idea of being dragged into a public court is so that it's open and transparent. So there is no cahoots going on. So there isn't a star chamber or a kangaroo court going on. So the public can view. So it's open justice. There is no such thing as privacy for child and youth courts. There might be some privacy to protect them. But in a public courtroom, that's the whole idea. You drag us into the public system, and then you don't like it when the public watch. Yours sincerely, Chris Hurd, Senior Solicitor, Officer of Legal Counsel, direct dial number 04 494 5346, extension 50346. If anybody would like to call Chris, please do so on 04 494 5346, extension 5036, or email Chris at chris.hurd@justice.govt.nz if you have any issue with what he's trying to tell me. By all means, express your opinion. He's a public servant. He's acting on behalf of the Ministry of Justice. He's getting paid by your dollars, people. So, if you think that's okay, go right ahead. P.S. on the bottom of this, underneath Chris's little name, I note your practice of ending emails with statements that certain situations are deemed to exist. I'm stating facts. I'm stating the fact that I've notified you guys, and the fact that you don't respond means you condone it. It's not that deemed to exist, it's facts that have happened, or that the recipients are deemed to agree with the stated position. Well, silence is acquiescence. I state a position. If you don't respond and deny that or rebut it in some way, then you do agree. It's exactly what the government do, and it's exactly the trick I picked up. If no response to the contrary is received within a specific time frame, such statements have no legal effect, and nothing can logically be inferred from a failure to respond within the stated time frame. It's exactly how it can be inferred. It's exactly what the government does. And why do I put those failure to responds? Because if I don't put a failure to respond notice on the bottom of my correspondence, no one replies. I would note, Chris, that you seem to respond within the allotted time frame, which makes your little PS at the bottom of your email somewhat irrelevant. So that's the letter, or the email, where basically he tells me I'm correct, I can record on the footpath, apologises, and in the next sentence bitch slaps me by telling me you got to give respect to get respect. Perhaps you should practice what you preach. Most public officials are elected to serve the public. No, they aren't put in power to rule. So, needless to say, as well as making me smile and laugh my tits off reading this, Chris, I thought to myself, oh, he's in for a doozy of a response. This is my response that I sent to Chris last night on the 7th of October.